Hundreds of millions awarded for a housing algorithm, tens of millions over a scraped prediction engine, a rival accused of stealing the secret formula behind home price forecasts. Predictive models aren't just math anymore. They're locked vaults of trade secrets, and the courtroom has become the battlefield.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
You're listening to Intangiblia, the podcast where we decode the invisible rules behind innovation. I'm Leticia Caminero, your host.
And I'm Artemisa, your unapologetically opinionated co-host. Today, we're talking predictive models, algorithms that don't just analyze data, they forecast the future, or at least try to.
Predictive technology powers everything from real estate pricing to fashion forecasting, insurance, and marketing. But when companies fight over it, the legal arguments often turn on secrecy, ownership, and intellectual property.
In plain terms, courts are deciding who gets to say that prediction is mine.
And before we begin, a quick note, Artemisa is an AI co-host, and my voice has been cloned with AI technology for this episode. This podcast is for information and discussion only. It is not legal advice.
Translation, I bring the sass, she brings the law, and neither of us is your lawyer. What exactly counts as a trade secret? Oh, easy. It's like the legal version of grandma's recipe. Valuable, confidential, and kept out of sight. The difference is, instead of soup, it's algorithms, data pipelines, and predictive models.
Legally, it has 3 ingredients. It has to be valuable, it has to be secret, and you have to actually make an effort to keep it secret. If you leave the recipe taped to the office fridge, it doesn't count. Lose the secrecy, and you lose the protection. Our first stop takes us to Texas, where a real estate startup called House Canary went head-to-head with Amrock, one of the country's biggest title and appraisal companies, at the heart of the dispute, algorithms that predict property values.
House Canary built automated valuation models, AVMs, that could crunch massive amounts of data and forecast what a house should be worth. Amrock wanted in on that tech.
So they signed a deal. House Canary would provide Amrock with access to its proprietary predictive tools. But soon, the partnership turned sour. Amrock accused House Canary of failing to deliver what it promised. House Canary countered, saying, Amrock wasn't just a bad customer, it was stealing their secret sauce.
And by secret sauce, we mean trade secrets, the algorithms, the models, the data pipelines, all the behind-the-scenes magic that makes those predictions work. House Canary claimed Amrock and its partners were misappropriating those secrets to build a copycat system.
The case went to trial. A Texas jury listened to weeks of testimony about code, data, and valuations, not exactly easy material for a courtroom. But the verdict was anything but boring. House Canary won over $600 million in damages, one of the largest trade secret awards in U.S. history.
The jury didn't just side with House Canary. They sent a message. If you treat predictive algorithms like your competitive crown jewels, the law might actually back you up.
Of course, the case didn't end there. Appeals follow, questions about whether the damages were too high and whether the claims were as solid as the jury believed. But House Canary v. Amrock became a touchstone, proof that predictive models can be litigated and valued as trade secrets.
And honestly, it gave every startup out there a bit of swagger. Like, hey, your code predicting house prices, that could be worth hundreds of millions in court if someone tries to steal it.
Our next case takes us to China, where the Supreme People's Court issued a groundbreaking ruling in 2025. The question, can the internal parameters of an AI, the trained model weights, be protected as trade secrets?
Basically, it's like asking, are the numbers inside the black box just math, or are they a company's crown jewels?
A company accused a competitor of misusing its trained AI models. We're not talking about the code itself, but the actual parameters, those millions of values that get tuned when an AI learns from data. Until then, courts usually treated code as protectable, but model weights were a legal gray zone.
And the SBC didn't hesitate. They said, yes, model weights are protectable trade secrets, which means if you train an AI to forecast stock markets, predict customer churn, or flag insurance risks, the trained weights themselves are legally shielded.
That's a big deal because it extends trade secret law into the very guts of AI. It's no longer just about protecting source code or data. Now, the trained outcome itself can be locked down.
And let's be real, that's where the value is. Training a model takes insane amounts of time, money, and data. Once trained, those weights are like a shortcut to intelligence. If a competitor swipes them, they've skipped years of work. China's courts basically said, nope, you don't get to do that.
This outcome is also a signal of how jurisdictions are racing to adapt AI law to AI. In many countries, it is still unsettled whether model weights can be directly protected as trade secrets. This case confirms they are protectable assets.
And it's not just a legal footnote. Imagine what this means for companies training predictive AI for health, finance, or logistics. Their competitive edge isn't just in their data or code. It's literally embedded in those billions of parameters. And in China, the courts just gave them a legal shield.
Maybe we should pause for a second. What exactly are these weights we're talking about? In simple terms, weights are the dials inside an AI model. Every time the system is trained, say to predict housing prices or forecast sales, it tweaks those dials based on the data it sees.
Think of it like a giant soundboard at a concert. Each knob controls how the music comes out. Train an AI, and you're basically turning billions of those knobs until the model's song sounds right. In technical terms, those knobs are the weights.
And that's where the value lies. The road code for building a neural network isn't that special anymore. Anyone can download open source frameworks. The magic happens in the training. Once the AI has adjusted those billions of weights, the model knows how to predict.
So when the Chinese Supreme People's Court said weights can be trade secrets, they weren't protecting the blueprint of the soundboard. They were protecting its exact settings, the tune version that actually worked.
And for companies building predictive tech, that tuned model is often worth far more than the code itself. That's why these rulings sent ripples through the legal and tech world. Now let's stay in China for another case that shows just how far companies will go to protect predictive tools. This time it was Alibaba, the giant behind Taobao and Tmall, going after a smaller firm called Shen.
Picture the scale. Taobao isn't just a shopping site. It's a fire hose of consumer behavior data. Who buys what, when, and why? Alibaba had a tool called Business Advisor that could crunch this data to predict trends, forecast sales, and guide merchants.
Zhao and Shen thought they could skip the hard part. They allegedly scraped Alibaba's platforms and tried to reconstruct the predictive insights for themselves. To Alibaba, that wasn't just bad manners, it was theft of trade secrets.
And the court agreed. In a major win for Alibaba, the judges said, this isn't just random e-commerce data. When processed and structured into predictive tools, it's a protected trade secret. Xiao Shen was hit with over 30 million RMB in damages.
What makes this case so important is the way the court framed it. They recognized that predictive marketing systems, the algorithms and datasets that let a platform forecast what consumers will want next, are more than just business know-how. They're legally protectable assets.
And let's be honest, that ruling is music to the ears of every platform economy giant. Because if your competitors can't scrape, clone, and resell your predictive engine, you've basically locked in your advantage.
It also sets a contrast with other jurisdictions where scraping cases often turn on copyright or contract law. Here, the Chinese court put it squarely in the box of trade secret protection.
Which means Alibaba didn't just keep its data, it kept its predictive power. And that in the 21st century is as good as keeping the crown.
Intangiblia, the podcast of intangible law. Plain talk about intellectual property.
Not all predictive battles happen in glamorous industries like fashion or e-commerce. Sometimes the fight is over industrial machinery, in this case, compressors.
Yep, compressors, the kind of hardware that keeps chemical plants, refineries, and power stations running. Shen Group, a major Chinese company, had developed predictive design software for compressor impellers, basically algorithms that could forecast the best design choices for efficiency.
Two of Shen's employees left to start their own venture, Shenyang Machinery. And what a coincidence. Their new company suddenly had software that looked a little too familiar. Shen claimed its proprietary algorithms and model databases had walked out the door with them.
The court didn't see it as coincidence. They agreed the ex-employees had misappropriated Shen's trade secrets, specifically the predictive selection software and the database of impeller models. Damages, about 25 million RMB.
This case is a reminder that predictive analytics isn't just about consumer behavior. It's embedded in industrial design, manufacturing, and engineering. Anywhere you have data and decisions to optimize, predictive algorithms become a valuable assets and potential trade secrets.
And here's the fun part. A compressor case might not make headlines in the fashion pages, but legally it's huge. Because if you can protect predictive models in industrial design, you can protect them in almost any field.
Exactly. The ruling set a precedent that technical software and databases used for predictive modeling are protectable as trade secrets, even in sectors far from the public eye.
In other words, whether it's predicting the next trending shoe or the next optimal impeller blade, the law is ready to treat your algorithms as treasures.
We move to Boston, where the dispute is about something much closer to people's daily lives: health insurance. Milliman, one of the world's biggest actuarial firms, developed algorithms to identify patient health data and use it in predictive models for insurance risk.
Translation, their software could strip names and IDs out of medical records, then crunch the remaining data to predict who might need care, how much it would cost, and how insurers should price it. That's money magic for the insurance industry.
Several of Milliman's employees left and founded a rival, Gradient AI. Milliman accused them of taking not just know-how, but also its patents and proprietary algorithms for the identification and risk prediction.
Which is spicy, because this case blends both worlds, patents and trade secrets. Milliman said, "We own patents on how this works, and you stole the confidential parts that weren't published, double punch."
The lawsuit alleged Gradient built its predictive tools on top of Milliman's de-identification methods while using Milliman's confidential client data. Gradient denied it, of course, saying it had developed its own independent tech.
As of now, the case is still ongoing in Massachusetts federal court, but it raises a big question for predictive analytics. How do you protect the line between what's published in a patent and what's locked away as a trade secret?
Because once you patent a method, the disclosure is public. What you don't disclose, like the fine-tuned data pipelines or model configurations, has to be guarded as a trade secret. Milliman's strategy shows how companies use both tools together.
And it's a perfect example of why predictive health models are so valuable. Whoever owns the IP doesn't just own software. They own the power to forecast billions in healthcare costs.
Our next case circles back to real estate, this time in the United States. If you've ever browsed Zillow, you've probably seen the Zestimate, a predictive model that spits out home values in seconds. For many homeowners, it's a love-hate relationship. For Zillow, it's a prized asset.
And apparently one worth stealing. According to Zillow, one of their senior machine learning directors left the company and joined Compass, a fast-growing rival brokerage. Zillow claims he didn't just take his LinkedIn profile, he took Zillow's predictive models with him.
The lawsuit alleged misappropriation of trade secrets, algorithms powering Zestimate, personalization tools like Claim Your Home alerts, and other predictive features that make Zillow sticky for users.
Compass, of course, denied it. They argued the employee used general knowledge, not proprietary Zillow code or data. That's a classic defense in trade secret law. What counts as secret sauce versus what's just experience in your head.
The case is still ongoing in Washington Federal Court, but it underscores a big tension. Predictive models are easy to describe in broad strokes, but the actual weights, code, and pipelines are where the value lies, and those can walk out the door with employees.
Which is why companies guard predictive teams like Fort Knox. Lose your lead data scientist and suddenly your competitor has an inside edge. Zillow clearly decided the risk was too high to ignore.
This case also highlights how courts act as referees in the employee knowledge versus trade secret debate. Innovation thrives on people moving around, but companies will fight to keep the most valuable parts of prediction under lock and key.
So the Zestimate isn't just about your home value anymore. It's about how much the law values predictive models themselves.
Now, from real estate to fintech. This case out of Florida is about predictive payment systems, software that could forecast, process, and settle alcohol invoices within 24 hours. For wholesalers and retailers, shaving time off payments can mean serious cash flow benefits.
Fintech, the company behind that system, accused its rival iControl of getting a little too familiar with its secret sauce. According to the complaint, iControl hired away former fintech employees who allegedly brought along confidential knowledge of the platform's predictive invoice processing software.
The heart of the case was whether that software, its structure, its predictive algorithms, qualified as trade secrets, and whether iControl gained an unfair edge by tapping ex-staff.
A Florida jury sided with fintech. They found iControl had misappropriated trade secrets and awarded damages, about $2.7 million in actual damages plus $3 million in punitive damages. Not the biggest payout we've seen, but still a solid hit.
This case is a reminder of how trade secret law often plays out in courtrooms. The technology doesn't have to be glamorous. If the software is valuable, confidential, and not easily replicated, it can qualify as a protectable asset.
And it shows the flip side of predictive analytics, not just about AI models and fancy machine learning. Sometimes it's the practical prediction of who pays what and when. And in the business world, that can be just as valuable as predicting house prices or fashion trends.
In short, the jury recognized that predictive financial software isn't just a business tool. It's intellectual property that deserves protection. Our next case is hot off the press. Juries, a healthcare startup, developed software designed to help providers manage Medicare and Medicaid billing with predictive analytics, automating compliance, forecasting costs, and streamlining reimbursements.
Sounds like a lifesaver for hospitals buried in paperwork. But according to Curise, Epic Systems, the giant of electronic health records, wasn't just a competitor, they were an alleged copycat.
The complaint says Epic pressured clients, misappropriated Curise's software and confidential client data, and used that to expand its own predictive tools. QRS framed this as a multi-pronged scheme, unfair competition plus trade secret theft.
Epic, of course, denied it, but let's be real, the power dynamics are fascinating here. Curis is a small startup. Epic is a behemoth. This case is a test of whether trade secret law can actually level the playing field.
And it's still pending in California federal court. No jury, no damages yet. But the stakes are high because it touches not only predictive healthcare software, but also data access. Who controls the predictive insights from patient records? the nimble innovator, or the platform giant.
And beyond the courtroom, it sends a signal. If you're a startup building predictive tools, your code and client data might be your only armor against big tech's shadow. Whether that armor holds up will depend on how courts treat trade secrets.
The Curious Bees episode is still unfolding, but it's already shaping up as a case study in how trade secret law intersects with innovation and competition in predictive health tech. So what do we learn from these cases? Predictive analytics is everywhere, from housing markets to healthcare, from fashion to fintech. And when the technology is valuable, companies don't just guard it, they fight for it in court.
Trade secrets are the weapon of choice. Forget flashy patents or copyright battles. The real action is in locked algorithms, confidential data sets, and tuned models. Courts around the world are treating them as protectable assets.
And that gives us 4 big takeaways.
1. Prediction is power and property. Predictive models aren't just tools, they're corporate assets treated like intellectual property in trade secret law.
2. The secret is in the details. From model weights in China to Zillow's estimate, value lies in the fine-tuned guts of the algorithm. That's what courts are asked to protect.
3. Employees are the weak link. Most disputes start when staff move, taking know-how, code, or data. Courts have to separate general expertise from true trade secrets, or global trends converge. Whether it's Texas, Beijing, or Brussels, courts are grappling with the same question. When prediction is proprietary, who gets to own tomorrow's forecast? The next time an algorithm tells you what house to buy, what shirt to wear, or what invoice will get paid, remember that prediction might be sealed in code, stamped as a trade secret, and defended in court like gold.
And that wraps up today's episode of Intangible Lab. Thanks for listening.
Until then, keep your data safe, your models secret, and your lawyers on speed dial.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.